Streaming. Oh, hello everybody. Hello everyone who is watching us now. I'm very glad to be here, cited by so brilliant professors, Professor Neve, Professor Magali, and Professor Vinicius Klein. I will just excuse myself not presenting myself. I'm Eduardo Gabbana, and that's it, Professor Vinicius Klein. And we have here Professor Neve. She's an associate professor at law. Just leave the airplane go, and then I can keep the introduction. Okay, after this dramatic pause, silence. So Professor Neve, as I was saying, she's an associate professor at the law department of the London School of Economics. Professor Neve has previously worked at King's College, London, and the University of Cambridge as a case handler at the Competition Authority of Ireland and as a competition policy consultant for the OECD. And Professor Magali is a lecturer in competition law at the University of Glasgow. She holds a PhD from the University of Leeds. Magali was the 2018 ABA's Antitrust Law International Scholar in Residence. She was a visiting researcher at Georgetown University. So, Professor Magali and Professor Neve, the floor is yours.
All right, so I'm going to share my screen so that I can give you all a brief overview of the DMA. And then after I've given this brief overview, Neve and I will have a bit of a discussion about whether the DMA is competition law, how it relates to competition law, and so on. But obviously we can't do that without actually knowing what's in the DMA. So I'm going to start with that. So what is quite interesting, but everybody already knows, is who is addressed by the Digital Markets Act, and that's what we call gatekeepers. Now, gatekeepers is really a subcategory of companies offering core platform services. The Digital Markets Act gives a list of services that are considered to be core platform services, and I've listed the most important ones on this slide. It's social networking, it's online search, cloud computing, operating systems, and so on. But not all the companies that offer these services are caught by the DMA. The DMA really addresses those that are gatekeepers. And in a nutshell, gatekeepers are companies whose platform is a gateway between a large customer base, between small, medium-sized enterprises mostly, and consumers. So if you have a business that wants to reach out to a consumer, they have to go through this platform. There are other things in the DMA. For example, it has to have an effect on the internal market. That's really about justifying this as an EU piece of legislation rather than being national. So the key thing to understand is that this is about gatekeepers. They have an intermediation position between consumers and other businesses. Now, these gatekeepers are subject to certain obligations and prohibitions according to the Digital Markets Act. And you'll find these obligations and prohibitions in Article 5 and Article 6. Now, I think there's about 18 obligations and prohibitions, and I've listed many of them on the slide, not all of them, but the most interesting ones. And there's a key difference between Article 5 and Article 6. Article 5 are obligations and prohibitions which are self-executing. So basically, the moment the European Commission says that a particular company is a gatekeeper, they have to implement these obligations in Article 5. Article 6 is a bit different, seemingly, because it says that these obligations can be further specified. The Commission can have a dialogue with the gatekeepers about how exactly these obligations need to be implemented. That doesn't mean they don't apply. They do apply, but to some extent, to the Commission's discretion, it can have a bit of a chat about what exactly it means by it. Now, it's not particularly clear whether there will be a lot of input from the companies or whether it's mostly the Commission saying, and this is what we want you to do. But in theory, there will be a dialogue about Article 6 obligations. Now, you'll see multiple obligations there. And we'll talk about the DMA and its substance more in a bit. But one of the things I find interesting is that there's a lot of different things in there, and not all of them seem to have the same objectives. So in a way, there's a bit of a mix between things that protect smaller businesses, things that seem to protect consumers. And so there's interoperability obligations, there's data portability obligations, but there's also obligations on the platform to actually share its infrastructure, share the data it possesses with other businesses. And so it's quite a wide-ranging, interesting list of obligations. Now, how does it actually work? So if you have a company that is designated as a gatekeeper, that designation happens by the European Commission. So it's a centralized, really, approach. The European Commission will say who are gatekeepers. Once you are a gatekeeper, you have to apply the obligations of Article 5 and Article 6. There is no effects analysis. It doesn't matter whether your conduct harms competition or not, whether there's any evidence that it harms consumers or not, it doesn't matter. The moment you're a gatekeeper, you have to abide by Article 5 and Article 6. There's also no defense. The exceptions that the DMA has are very limited. There's an exception that if there are external, exceptional circumstances that endanger your economic viability, the Commission might consider saying that one particular obligation doesn't apply. It seems like a very, very small way out. And then you'll see that there's exemptions for overriding reasons of public interest. This is a very EU thing. Any big piece of EU legislation will talk about public morality, health, and security. Students of EU law hate these because they're notoriously difficult to define and also not very useful, I think, in this context, but Niamh might disagree with me. I can't really see the extent to which this would be a way out of the obligations under Article 5 and Article 6. What's interesting is that these obligations are seemingly a limited list, but in actual fact, the Commission can update them as we go. So you've got the DMA is passed maybe in the future at some point, and then the Commission can decide to add more obligations to Article 5 and Article 6 by way of delegated acts. If it says, well, we have done a market investigation and certain practices are not currently in the list, but they are actually hurting contestability or they are unfair. The meaning of unfair, according to this article that gives the Commission further possibilities to update the list, is any act that creates an imbalance in the rights and obligations of a gatekeeper compared to other businesses, users of the platform. Any advantage that a gatekeeper has over other users could qualify as being unfair. There isn't really a reference to advantage in competition. So I think this is an open question, the extent to which the Commission has to consider competition when it updates the list, or the extent to which this is really nothing to do with competition and quite a broad list. And we might touch upon that a little next. So before we move on to the real discussion, just a quick overview of the legal basis and the goals and the relationships with other laws according to the text of this proposed DMA. The legal basis is not competition, it's harmonization. So this has been proposed as a law that will unify the rules for the European Union as a whole. There is a bit of a question by some people whether this was for procedural reasons, because if the Commission adopts a principle, a rule like this, they can go for a much easier adoption process of the law than really if it's for an objective of competition policy. But leaving that kind of opportunistic interpretation aside, this legal basis would mean that the rules would have to be the same across the European Union. And you can see that because the text of the DMA says that there can't actually be deviation at a national level, but it is far from clear what is meant here. The DMA says that competition law can still apply at an EU level because it has a fundamentally different objective that complements the DMA but is distinct. But then when it comes to national competition law, so for example, Germany's own competition law separate from the EU, it says, well, that law can apply, but only if it's not really about gatekeepers, or only if it goes further than what we're doing and imposes additional obligations. This is where it isn't quite clear what is meant by that. And some of you may know that Germany has actually adopted a new provision of competition law that actually addresses gatekeepers. They don't call them gatekeepers, they call them undertakings with a paramount significance across market, but I mean, that's gatekeepers, right? So it's not quite clear what the relationship would be with German competition law. There's this weird, interesting feature of EU competition law that the member states have been given some leeway to adopt stricter abuse of dominance provisions. And this was a compromise in the early 2000s, mostly because Germany and France wanted to keep their own rules differently. And so I'm wondering if we'll have another German-France backlash that leads to another compromise. But anyway, this is all speculation. The text of the DMA is on the slide, and I'm just talking too much. So with this little overview of the DMA, I think it is a nice idea to start talking about what is the DMA. Is it competition law? This matters for a variety of reasons. One of the questions obviously is what happens if a company has to abide both by the DMA and competition law. According currently as it stands, if these two have different legal interests, then a company could theoretically have to abide by both. And if you look at the text of the DMA says explicitly, we have a different legal interest in competition law, so you'll have to abide by the DMA and competition law. It's not quite clear if that's going to stay in the text. Now, Niamh is much more of an expert on this than I am, because she wrote a book, which all my students now have to read, Niamh. And in that book, she makes a distinction between competition law on the one hand and regulation on the other. So I'll let you talk it through and tell me where you think the key distinctions are.
So, hi everyone. Thank you, Magli, for an incredibly, I think, succinct and accurate overview of an incredibly complicated piece of legislation. And thank you for inviting me to be here today. What I think is really interesting is that the fact is that we spend so much time talking about the DMA and is it competition law and is it good competition policy? And I think that's because almost everybody who's interested in the DMA and is talking about it is a competition lawyer. And so we all measure it against the standard that we have, which is what competition law looks like, what competition policy sort of approximates to. And we're asking it from a very specific perspective. And I wonder if we took a slightly different, perhaps more regulatory perspective, we might be asking different questions. Perhaps, are these valid regulatory goals and is the instrument well designed to achieve them, rather than do they approximate to something that we have decided is a good idea? Just to talk briefly, I suppose, about this very abstract question of what is competition law versus what is regulation. And of course, regulation is an incredibly complicated term, and you could define it as broadly that it would include all forms of competition law. But if you want to set up some conventional, I suppose, dichotomies between the two instruments, I'm going to suggest 6. And we might talk a little bit about the extent to which the DMA matches or diverges from the kind of the archetype of regulation or the archetype of competition in these dichotomies. The first is very obviously the kind of sectoral scope. What actually falls within the purview of the rules. Competition law is well known as being the residual regulator, so it applies in all markets unless they are exempted. The big example of an exempted market under EU law would be, well, partially exempted agriculture. So agriculture, the competition law rules don't really apply, but all other markets, they do. The DMA, of course, we're looking at a much narrower subset of economic activity, not just digital markets, but 8 core platform services in the digital sector. So it's obviously a very specific instrument rather than the much more general instrument of competition law. There's also the temporal nature. So we classically think of competition law as being enforced ex post. It sets out these broad prohibitions. Undertakings operate in the market. If they infringe the prohibition, then we take retrospective enforcement action. Of course, the perspective of the DMA is very different to that. We identify our gatekeepers, and then going forward, this specific list of obligation applies to them. So it's really kind of a much more ex ante perspective, and you know, I think the phrase that Michel Gall used was that firms are put on notice. So if you've got gatekeeper status, you're put on notice, you can't do these things. And if you do those things, if you fail to live up to your obligations, then you can face enforcement action on that very specific basis. The third question is what values are pursued. Typically, regulation can and does pursue a much broader range of socially beneficial values than the pursuit of competition law. So what does EU competition law aim to achieve? Well, it would differ about whether you'd ask Advocate General Niels Wahl, who would say it's all about efficiency. If you ask Advocate General Juliane Cocotte, she'd say it's about maintaining effective competition, which is a rather broader idea. But I think both would identify a kind of core objective of competition policy about keeping markets open and undistorted and functioning efficiently. The DMA has these two clear objectives. They are about protecting contestability, which I guess you could sort of approximate to effective competition, but the competition doesn't necessarily need to be effective in the sense of efficient. And so again, it's a slightly more structural, less economic idea. And this idea of fairness in markets, and fairness is such a nebulous idea and isn't defined in the DMA. And so if you look at the case law of the European courts, because of course the notions of fairness are found in the EU competition rules, the courts have historically interpreted fairness as something that looks quite like efficiency, but that doesn't seem to be the idea in the DMA. So what is fairness actually going to mean? We don't have a really good idea if we're looking at the case law. Fourth, you might think about the nature of the obligations that are imposed. So competition law, if you think of the antitrust rules, these two very broad and slightly amorphous prohibitions, which are then sort of specified in the case law and adapted on a case-by-case analysis. We ask, has an undertaking abused its dominant position? Has it engaged in anti-competitive coordination? Whereas the DMA is a much, much more prescriptive document. It says these are precisely the sorts of things that undertakings cannot do if they've been designated as gatekeeper status. As you mentioned, Maggie, there's a bit of flexibility in Article 6 about how the requirements can be effectively enforced in certain circumstances, but really it's quite clear what you can or what you cannot do. And it's a much more prescriptive list of obligations. A fifth dimension, and something I think we might talk a little bit more about later, is the question of the kind of dynamic versus static quality of competition law. So the whole idea of competition law is it's supposed to be a dynamic instrument. If you look back to some of the earliest statements about the Sherman Act in the US and the FTC Act in the US, they are all designed to kind of counter the inventiveness of firms. So firms are really, really good at figuring out how best to make money, and how best to make money in ways that might actually be to the disadvantage of everyone else. So we need a rule that's going to be able to adapt to reflect that inventiveness of firms. The big constraint on that, of course, in the EU context is the jurisprudence of the Court of Justice. So, of course, the concept of abuse of dominance is a flexible one that can evolve, but it evolves within the established case law. And I think there are many people who would be the strongest proponents of the DMA see that established case law as a hindrance to effective enforcement. At present, we cannot tackle the sorts of problems that we want to tackle because we need to show that dominance exists, and that's a difficult, concept to apply in digital markets. Or we need to show that once you're dominant, you're abusing that dominance, but actually maybe we want to just pursue the market power as such. And so the DMA is really about sort of, I suppose, escaping some of the consequences of the case law. It has a predefined list of things that gatekeeper firms must not do or must do. In terms of whether it's dynamic, well, it seems to be dynamic one way, which I find really interesting. So there is scope for adapting it. There's, I think, updating in Article 10, and then Article 36 also has some possibility of updating, revising. But it's only updating in one direction. So it's only foreseen that either the Commission or the Council and Parliament might want to add new obligations to the list. And there doesn't seem to be any scope for removing existing obligations, even if as markets evolve, or it's not foreseen that you would want, as markets evolve, to remove things from the list, which is really interesting if you compare it with EU telecoms law, because the whole point of EU telecoms law, the assumption is that the obligations become less as competition increases in markets, obligations are rolled back. So the regulation is all about rolling back the burden, whereas in the DMA, we just seem to be assuming that we're going to just, the tentacles of regulation will spread out ever further. The final point where we might see a distinction between competition law and regulation, and this is where actually it's an almost complete overlap between the DMA and competition law, is the qualitative nature of the infringement. What seems to be foreseen under the DMA in terms of how the rules are infringed or enforced, you'd have enforcement by the European Commission, and they would take administrative infringement decisions. They might also be able to enter into settlements, but they can impose really high fines. Those fines are going to be the same magnitude as competition fines. And if you look at the enforcement chapter of the DMA, it looks almost identical to the enforcement chapter of Regulation 1 of 2003, which is the Commission's own enforcement powers. The big distinction is there doesn't seem to be much scope for private enforcement or member state enforcement, which is something that I noticed that the European Council issued its concilium. So this is going through the legislative process at the moment. And a couple of days ago, the Council issued its perspective on what member states are saying. And one of the big things that member states are saying is give us more of a role, give us something to do. If we're going to have this really big set of rules, it doesn't make sense to have it entirely centralized in Brussels. But those, I guess, would be the sort of the arguments for and against seeing competition law, and the DMA is essentially the same thing.
Thank you. I think in your book you make a point which is actually goes to the heart of this, which is even though you have that distinction between competition law and regulation, in actual fact in the EU we sometimes use competition law to regulate, and particularly to fill a gap or to push the adoption of regulation. And so maybe you can talk a bit more about that, and then we can each pick a case and explain how we think that case might have led to the DMA.
Yeah, absolutely. So, I mean, I guess it's very straightforward. It's this gap filling notion that kind of going back to Hovenkamp's idea of competition law as a residual regulator, it's always in the background. It's usually not very well adapted to a particular market problem. And sometimes, fitting a particular market problem into the I suppose, either the pegs of abusive dominance or anti-competitive agreements can be a bit forced. But if you have nothing else available to you, you can use competition law to try and solve the problem because it has this residual applicability. And you might be doing that either because you are, the regulatory agenda hasn't caught up, the problem is new. And this, of course, would be an issue in digital markets where business models are always evolving. Back to this point about the inventiveness of firms when it comes to anti-competitive behavior. So competition law is there and it has that adaptability. Or it might be a more political problem. There might be resistance to actually regulating. So it's a well-identified problem, but there might be lobbying, or something that happens a lot in the EU is that it's recognized as a potential problem, but you can't get agreement. And so, of course, in the EU, you've got 27 different sovereign countries need to come together and decide that this A is a problem that merits EU level intervention, and B, they need to decide on a single course of action. That can also often take a very large amount of time. If you look at, the EU got merger control 30 years after it got its sort of abusive dominance and its anti-competitive agreement rules, just because the member states didn't want to give up that power. What the Commission has a tendency to do is take in strategic enforcement cases. So it did in the merger control case. It took some very strategic cases when it wanted to harmonize the rules on airports and aviation. So it basically starts attacking all these national champions, airlines and airports in the member states. And pretty quickly the member states decided, okay, let's have a regulation rather than ad hoc enforcement by the European Commission. So it's something that can certainly, it can either indicate that there's an emerging problem which merits regulation, or it might be something that's more strategic where you're trying to pragmatically plug a gap that exists and just it's really difficult to actually get regulation there in place.
I think there is an argument. I mean, I'll just disclose that I was not very impressed with the Google Shopping case in the EU. So anything I say is a bit biased against that case. But I think, in my opinion, when that case first arose, and there was a deviation from what was happening in Brazil and what happened in the US and in other countries, I was a bit confused about what was happening there. And in retrospect, completely taking what Niamh has just said and trying to plug that, I could say, well, they saw a problem, tried to use competition law, or they hoped somebody would take action and they used competition law to prompt that. I don't know. But that to me would make me feel better about the Google Shopping case. Why? Because it was a weird case. So I think most people are familiar with the Google Shopping case, especially competition law people, because this happened in loads of jurisdictions around the world. And I've had the pleasure to try to wade through CADE's decision on Google Shopping, which actually looks at both what happened in America and what happened in the EU, and came up with some kind of hybrid answer, which to me was a lot more impressive. I guess it's easier to look at what everybody's doing wrong and then do it better. What really was interesting about the Google Shopping decision is that you had Google in a way that acted as this platform with its search engine, where you had different other companies reaching out to consumers. So this is the gatekeeper notion. You've got these comparison shopping services. I'm still not quite clear how we're defining that, but these websites who show pictures, different products, and show the different prices, and then make money if you click on it. They were using the search engine to try to reach out to consumers, to you and I. So if you wanted Adidas shoes, if you put in Adidas in the Google search engine, you could see in the search results some comparison shopping services. Whether you clicked on it or not, that was another question. The comparison shopping services were arguing that people stopped clicking on them because what Google had done is it had put a competing comparison shopping product at the top of its search engine. Really, what that shopping unit was just another way for Google to make money from advertising, but it did that in a separate way from the rest of its search engine. And there was a discussion about whether this was a violation of competition law. The European Commission said that there was a violation of competition law because that shopping unit at the top was prettier than the other search results. So we like pretty things. It's a nice little box, it's flashes, so you're going to click on it, rather than the other blue link search results, which weren't as pretty. It also added that the search results of comparison shopping products were being downgraded. Google was arguing that's because nobody likes them, and they were arguing, no, you're doing this on purpose because you don't want us to compete with your product advertising at the top of the page. This is a debate that's still continuing. The Commission came up with a decision, but there has been a court hearing in the General Court where they're still debating this. Are you doing it because you think we're competitors, or do you just think we're bad quality? Still going on. The Commission, I think many know, came to the conclusion that it wasn't doing it because the quality was inferior, but because it didn't want that competition. Now, what I didn't like about the decision is I had no idea what the law was, right? So in the EU law, competition law evolves organically. So it's not as if we've got this really clear list of what you can and cannot do, or it would be regulation, right? But it evolves organically. But still, to some extent, you hope that principles that existed in the past will somehow be applied to future cases. This seemed to me like a hope that didn't materialize, because there were different ways you might have framed the Google Shopping case in the EU. You could have said it's a refusal to supply and try to apply those conditions, but that didn't happen. An argument was that Google Shopping was really about unequal treatment, so that the comparison shopping services were being treated differently from Google's own product. And a lot of people were saying this might be a discrimination problem. And indeed, in the EU, under EU competition law, there is a part of our article that says that it's an abuse of dominance to treat trading partners differently in such a way that they get a competitive disadvantage. The problem with that is that what happened here was arguably not about trading partners, because there was no contractual relationship between Google and the comparison shopping services. But even more importantly, they weren't being treated differently. They were all being treated badly. So if you're going to try to apply this, the negative treatment applied to all comparison shopping services. They were all subject to the same algorithm. The only one who wasn't subject to that algorithm was Google's own product, Google's own comparison shopping. So the commission said, well, it's not a discrimination case, it's a self-preferencing case. You can't treat your own products better than the products of other companies. Okay. I'd never heard of that before, but I might be wrong. So I think in retrospect, this is now in the DMA. And what was arguably not something we'd seen in competition law before, but even arguably not necessarily about competition as such, because this disadvantage hadn't anything to do with efficiency, but it was really about the opportunity of businesses to reach out to consumers. That's now in the DMA. That's now a self-preferencing category, something you're not allowed to do if you're a ranking service. And so in some ways, that decision filled a gap. But was it a gap of competition law, or was it just something that people didn't like Google doing? Google had control over this ecosystem where businesses reach out to consumers. And there was, I think, a fear that Google could use that to its own advantage, and that wasn't liked. Is that a competition issue? I'm still not convinced it is, but people obviously disagree with me, so take what I'm saying with a grain of salt. But it's no longer relevant, that question, because it's been lifted out of this decisional practice into the DMA. So in a way, we got a case that I didn't like, and now we've got regulation that will apply this for years and years to come. So to me, I actually feel better about Neve's theory of gap-filling competition law. It makes me feel better. And this is how I'm going to look at this case forever and ever. It filled a gap that wasn't related to competition law because new regulation was supposed to arrive. I think, Neve, you have another example of such a case. You might disagree with me, feel free.
Not at all, but actually, and this is the difficulty of using competition law to fill these gaps, is that you then have competition law precedent, which says it is a violation of Article 102 to engage in self-preferencing. And so the Commission is pretty gung-ho in using that new rule in an ongoing investigation against Amazon in the Amazon marketplace. So Amazon is obviously the leading, I'm not going to say dominant, I don't want to prejudge that, but it's certainly the leading online marketplace in the EU, in European countries. So by online marketplace, it provides intermediation services. Third-party retailers can list their goods online, and Amazon provides the service by which sellers and buyers meet and can conduct their transactions online. So when you go on Amazon looking for something, you sometimes get Amazon offerings, but you're very frequently buying from a third-party seller. What it is accused of having done, and this is an ongoing investigation, the Commission issued a statement of objections late last year, so it's likely we will see an infringement decision some point this year. They've used the Google shopping precedent, and they've said, well, this is unfair preferencing. It's unfair preferencing of Google's, of Amazon's position of dominance in the intermediation services market, where it acts as a marketplace. What it's doing is it's basically looking at what are the best sellers. It's figuring out what are the best selling products coming from the third-party retailers, what's selling well, at what price point to whom, and it's just copying them. It's going into business against its own customers in the sort of the retail market. And it's able to do this because it has such privileged access to all of this information. So it can figure out, in the online space, it knows exactly what's selling, when, to whom. It knows, what customers put things in the basket, but then don't actually check out or whatever it might be. It is such an amazing information advantage, and it's using that to compete downstream in what's considered to be an illegitimate way. And it's very much a question of unfair competition. There doesn't really seem to be much of a claim of inefficient competition or anti-competitive well, I guess it's considered by the retailers probably to be hard in the competition sense, but they're not really making a sort of an efficiency type of argument here. It really is very much linked to this idea in the DMA that certain practices just seem to be unfair. Again, this seems to be covered by the DMA. If you look to Article 6.1, so the 6.1a, so the very first obligation for gatekeepers susceptible to being further specified, gatekeepers must refrain from using in competition with business users any data not publicly available, which is generated through activities by those business users, including by end users of those business users of its core platform services. So there would be this absolute prohibition in the DMA on those practices arising, although because it's one of these kind of susceptible to being further specified requirements, it's possible that this would be tailored to the particular circumstances of the online retailer. It might just be worth also mentioning one further case, if I can, which isn't at the European Commission level, but is a very well-known case, which is the German Facebook case. And that's an interesting example of one of these Article 5 prohibitions. So outright prohibited, and there's no scope for kind of nuancing the obligation. In the German Facebook case, Facebook is essentially, the German Facebook case is against Facebook's very business model, which is gathering personal data of users across multiple services, building a profile, and then targeting ads at those users. The Bundeskartellamt held this to be a violation of the German rules governing abuse of market power. They didn't apply Article 102 very, very contentiously, and that's something that the German court has said they think is formally unlawful, at least the fact they didn't explain why they didn't do that. But what they did was they applied data protection norms coming from the GDPR, coming from EU data protection law. They said these violations of these norms by Facebook is, and Facebook has a dominant position, failing to abide by these is essentially an exploitative term and condition, and it is an abuse of market power. It's an extraordinarily controversial case because it basically takes a norm coming from what in the EU is human rights law. So there is a fundamental human right to data protection in the EU Charter of Fundamental Rights. It translates it into the substance of an antitrust abuse simply by virtue of the fact that Facebook is held to be dominant in the German market, and says it's an antitrust violation now. This would also be now, this is kind of outright prohibited, this behavior is prohibited by Article 5.1a to the extent it doesn't comply with the GDPR. Why I think the Facebook case is an interesting one is because unlike the Commission in Google Shopping, where the Commission insists they say it's well established that these practices, for 30, 40 years, they're citing 40-year-old case law. It's well established that these practices are unlawful. You think 40 years ago, you couldn't have imagined a search engine would exist. The Bundeskartellamt, on the other hand, has been a bit more honest. And they said, look, it's a new problem. We're making new law. And they kind of basically said they're filling a gap, and they have to fill the gap. I should admit they have to fill the gap because the regulator, when it comes to data protection for Facebook, is from my own home member state of Ireland, and we're a little bit more laissez-faire when it comes to regulating. And so the Irish regulator has really taken their foot off the gas in terms of pursuing Facebook, although they do seem to be speeding up now. They've listened to the criticism. But the Bundeskartellamt was filling a gap, not a gap in the regulatory framework, but really a gap in the regulatory enforcement framework. They couldn't use data protection law because they didn't have jurisdiction that lay in another member state. And so they use competition law very creatively. They at least acknowledge the originality and the fact that they're doing this quite strategically. The more contentious question is whether it should stand, I guess, as a finding of competition law. But as you say yourself, it's sort of irrelevant now if Article 5A of the DMA becomes law, because it's just going to be prohibited outright.
So, I mean, it's interesting. So you've got these things that are controversial competition law cases, and there are appeals going on. For the German case, there is the Court of Justice question. So there is a question at the EU level now with, should a competition authority even act as a data protection officer? Should they even get involved with data protection questions? but it might indeed become irrelevant. So you've got these controversial competition law cases people don't like. Not all of them. There's people who love the Google shopping decision who've told me 1,000 times they disagree with me, so fine. But some of us don't like them. But it's fine. They are now in regulation. And if this regulation gets adopted, it doesn't matter to some extent that they are controversial in competition law, except for one thing, which is that as the Court of Justice's jurisprudence now stands, a company could be found to infringe first the DMA, be fined there if they don't comply with it, and then second, be fined again under competition law. So 2 times 10% of your annual turnover. It's going to be nice for lawyers, right? We're going to have a lot of fun with this. Leaving that aside, it does raise quite an interesting question, which is the DMA is set not to be competition law, but it ports ideas from competition law enforcement, whether it should have been there or not, leaving that aside, into the DMA. And if you look at the goals of the DMA, the goals are contestability, which is a broader notion than just efficient competition. It's really about market structure more than it is about the actual content of the competitive relations. But, okay, but in addition, it talks about fairness. And it's not exactly clear what this fairness in the DMA means. There's different ways of interpreting it. The impact assessment study to the DMA actually calls anything they don't like unfair. Okay, so there's a leveraging of market power that's unfair. So in their sense, anything that is harmful is unfair. So I don't think that is a very useful way of going. The DMA itself refers to a notion of fairness in Article 10. Now, Article 10 is this article that allows the Commission to add obligations to the list. There it says that things are unfair if there is an advantage a gatekeeper has over other users of the platform that is disproportionate to the service it's offering. It's not quite clear how disproportionate would be interpreted. So the question here is that a notion that we know from competition law? Is it something different? We talk about fairness in competition law in the EU, but mostly we talk about it when we want to see why the Commission is justifying action, right? So the Commissioner will stand up and say, I have decided to do an investigation against Google because I think they are treating consumers unfairly. And so it's a way to it's a PR statement, I think, to really say, this is why we're taking this action. This doesn't mean unfairness isn't a concept in EU competition law. It is to some extent. Article 102, our abuse of dominance provision, says that you can't really charge unfair prices, have unfair terms and conditions. But this has been notoriously difficult to interpret. My students kind of hate it because I spend so much time on it. And then if I ask them an essay question about it, they're like, we still don't understand it. That's the right answer. If you say you don't understand it, you've completely understood the jurisprudence. Unfair is really difficult to define. And so to some extent, there has been a reluctance to actually bring unfair terms and conditions cases at the EU level. At the national level, this has lately become more popular. You've got, cases against pharmaceutical companies and cases against digital companies, including the German Facebook case. I do like the Bundeskartellamt because they were quite open about what was happening there. But in a way, there has been a comeback of the notion of unfairness in competition law. But at least there is still some kind of pretense that there's a link to competition. So it's the idea that if the market had been competitive, if there hadn't been market power, there wouldn't have been these unfair terms and conditions. The DMA doesn't even do that. The DMA just says, don't be unfair. And any advantage you have, don't use it because, it's an advantage and you're a gatekeeper. You shouldn't use advantages compared to other companies. I genuinely don't quite know what's going to happen with this, but I find it really fascinating because to some extent, to me, that indicates it's not competition law. But when I listen to some of the rapporteurs for the European Parliament about it, they're adamant this is competition law. And if we've got time, I can come back to why I think this is the case. But I've been doing empirical research into German competition law cases. And I think they might be right when it comes to German competition law. where fairness is an important element. But in EU competition law, I don't really think it is. I don't know, do you agree with that, Niamh?
Yeah, fairness is such a nebulous notion. I think you're absolutely right that in the last, since late 2014, which happened to coincide with the arrival of Commissioner Vestager, a woman who I greatly admire, but I think is a very good politician, she has really switched the rhetoric to that of fair competition. So we moved away from efficient competition, because who cares about efficient markets, but it's all about fairness, and fairness for you and me and the little guy. And she also, when she takes competition cases or she gives competition speeches, she talks about fair wages and fair working conditions and things which obviously are incredibly important at a European level, but are not usually something that's discussed by the competition commissioner. That would be, kind of sort of much more the purview of the kind of more social aspect of Europe. When I look at the DMA and the structure of the DMA, and it's something that hasn't really been discussed very much, and I think it's because everybody who's talking about the DMA is a competition lawyer rather than a European private lawyer. What the structure and I guess the focus most closely resembles for me are the rules on unfair contract terms. So in 1993, Europe introduced what the Unfair Contract Terms Directive, and then in 2005, the Unfair Commercial Practices Directive. And they basically both do exactly the same thing. They say there are certain either contract terms or commercial practices that we're going to deem outright unfair, and you need to have national legislation in place. So these are directives rather than specific regulations, national legislation in place, which makes these illegal. What's the context? It is specifically, there's particularly the Unfair Contract Terms Directive. It's the relationship between buyers and sellers. It can be any seller, but the buyer has to be a natural person. So it's a little human person who's purchasing whatever they're purchasing, a washing machine, or they're purchasing a pair of shoes, or they're purchasing their groceries, or whatever it might be. And the terms have to be what you would kind of call, I think, a contract of adhesion. So not individually negotiated. So if the little natural person actually is quite a big, powerful customer and can negotiate their own contract, there's no protection there. But if they're considered to be a small, vulnerable person, and there's a mismatch, a kind of a potential power imbalance there, then there's specific EU level protection for them. And the standard is unfairness. We don't think in that situation where you have this power imbalance that sellers should be permitted to impose these unfair terms and conditions or to use these unfair commercial practices. What's really interesting to me about the DMA is it seems to take that notion of this imbalance in power and extract it kind of to the scenario where you've got, on the one hand, really big sellers, and the other hand, much smaller sellers, potentially much smaller sellers. And that's an idea I think you also really see in the Amazon marketplace case, this idea that it's not just sort of individual consumers who deserve a kind of a fair marketplace, but small and potentially medium-sized enterprises who won't be able to kind of individually negotiate with the gatekeepers over the terms and conditions of access they're getting. They're going to just have to take what they're given. Well, they're also going to be protected. So in a way, I mean, it might be a bit ridiculous to say this, but I see the DMA probably most obviously as a kind of form of consumer protection law, but for small customers. It's the same logic, but in the commercial arena. How we justify that or how we square it with competition policy, I really struggle to see the DMA as a competition law instrument, although I know there are many, many commentators who disagree with me on that.
And this is where I think the first time in the talk where I might actually come in and disagree, because Dr. Orbrook and I have been doing empirical research, and basically our empirical research has been into the competition law of different member states and whether they abide by the allocation of powers across the EU and the national level. But what we've come to realize is how differently they interpret competition law. And there seems to be this notion that protecting small and medium-sized customers against imbalances in power is part of competition law. And this to me was actually quite a shock. I had come from a more old school idea of competition law and never quite understood why there had been such a disagreement between Germany, France, and the European Commission when the power of competition law became decentralized. And now I realized it was because their notion of competition law was so different. Their idea of unfair practices was inherent in their competition law, which I found fascinating. Our empirical research is a bit of a nightmare because there doesn't seem to be any coherent question or even just thinking about what competition law means across Europe, which is great when we're trying to create regulation that we hope the rest of the world is going to copy, right? So we don't agree on what competition law is, but everybody else here copy what we're doing. Anyway, so I think it might be competition law if you look at German competition law.
Yeah. And I would just, this is why I think this kind of contract law analogy is actually really interesting, because exactly the same diversions exist or have existed in European private law. When the Unfair Contract Terms Directive came in 1993, the English contract law scholars were like, what are we supposed to do with this? Why are we protecting people from unfair terms and conditions? Whereas, of course, if you look at the German law on this, German consumer contract law essentially assumes that all consumers are morons who need to be protected from themselves. So you have these really wide divergences. And it's interesting that, I suppose, when you try to harmonize at a European level, you kind of, are you going for the kind of lowest common denominator? This is it's one of the critiques, I guess, of, you know, regulating this harmonization. What is it? You know, it's obviously you get a camel, a horse designed by a committee as a camel. Is EU legislation a camel? Because we're trying to accommodate so many different perspectives within these value judgments within the legislation.
I'm going to keep that analogy, a camel. No, but it is interesting. I mean, Belgium has introduced a new provision, an abuse of economic dependence provision in their competition law. So they're basically copying that German-French idea. And I mean, I go back and forth on this. It's a thing of economic democracy. It's the idea that you protect smaller market participants against the power of the bigger players. And I actually, in theory, in principle, quite like that idea. I'm just not sure if that's competition law in terms of antitrust law, or if it's a different thing. And so I actually personally wish we'd clarify that before we went completely into the DMA and added another layer. On the bright side, it makes my empirical research so much more valuable. So I'm sure somebody will publish it now. Before that, we actually got the comment, but why does it matter? And now I know why it matters. So I'm quite happy about that for my own career. But for general, coherence in law, I am not so sure. I think maybe we've got a few more minutes before we open to questions, I think. So maybe we can just quickly touch on enforcement of this, because obviously that national versus EU divide actually raises the question. So the DMA is going to be, in this draft, enforced by the Commission, right? Completely by the Commission. The Commission will say who the gatekeeper is, will then make sure they live up to their obligations. And there has been a lot of discussion, a lot of member states saying, hang on, we want a piece of this pie. We want to be involved in this enforcement. So most of the discussion now has been on member states saying they want their competition authorities, so not a different authority, but their competition authorities, to also be able to check whether gatekeepers live up to this. But there's a few other questions I think that are even more interesting. So to some extent, if the Commission has to share their competences, I think the legal basis of harmonization might be a problem, but that's just procedural. But there's no complaints procedure in the DMA. You and I can't bring a complaint. There are questions about what happens if the Germans continue applying their law because they have 2 ongoing investigations. And can small and medium-sized enterprises actually bring private enforcement? So all of these questions are up in the air. So Niamh, if you want to touch about any of them, feel free.
Well, maybe I'll just take the point about no complaints. I guess I see that as part of the reason why this is not competition law, because you're not complaining about distinct instances of anti-competitive behavior. It's regulatory compliance. It's the duty of any sector-specific regulator to make sure that the basic, quite specific obligations in a sector are being respected. I mean, I'm sure the Commission, if it got an email that said some company X is not adhering by Article 5F or something like that, that obligation, they wouldn't ignore that information. But it's not really kind of designed as these individual violations. It's not law enforcement, you're not it's not a prosecution in that sense. It is that kind of more regulatory idea. And I think there has, one of the reasons, like the call for greater, I suppose, private enforcement at least, is that if we say it's essentially about protecting fairness for individual businesses, if it's really about, specifically protecting small and medium sort of enterprises and making sure they have a fair shake within digital markets, well, then they're going to be, I suppose, best placed and most motivated to actually enforce those rules. There is this really big open question as to what's going to happen when all of this stuff hits the courts. There's a huge question of whether the courts will think that the complete absence of rights of defense or really any sort of fair procedures in terms of all these designations and administrations are okay. But there's also the question of whether the court might do a courage and cren and sort of pluck from nowhere rights of private enforcement on an effectiveness basis. There's just so much that remains unspecified and unknown, I think, within the current draft.
Can I give you my view of the DMA, and you tell me whether you think I'm completely wrong here, right? So looking at the fact that the Commission is a central enforcer, the member states, as they are not involved, except for some dialogue, but really. But also looking at the obligations, to me, the DMA is accepting that to me, it's like, okay, we accept that there is no competition. We accept that there's going to be a handful of these platforms. And so there might not be competition between different ecosystems. So we're going to try to make sure that what happens in the ecosystem is fair and nice. And so there's some mentions of contestability requirements, but most of these contestability requirements are about allowing adjacent related products to plug into the platform rather than having some competition with the platform. To me, it's really the Commission accepting that there is no competition, deciding that this is about just accepting the inevitable and pragmatically protecting small companies. But they want to keep a hold on that because they know it's a bit of a pragmatic thing. And if you have too much private enforcement, it might completely become a mess. Obviously, sorry, European Commission, might be completely wrong here, but that's how it reads to me.
It's an interesting perspective. I guess I think I would find it very difficult to say that at a macro level, Amazon, Facebook, Google, Microsoft don't compete extraordinarily vigorously against each other. So there's a huge amount of competition going on between these gatekeepers. The point might be that there's, in these specific market segments, there's an absence of competition. But of course, the DMA refuses to define any markets. So we can't actually identify where the markets, where the problems lie. So you're kind of saying, well, it's not a macro level problem, it's a micro level problem, but we also don't want to define what the micro level is. I think you're absolutely right that this is a hugely pragmatic piece of legislation. I think I'm a little bit of a cynic, and I think that this is what you might call, I think the criminology literature sometimes calls moral panics. I think in the last 5-10 years, everybody has decided that the digital economy is the most evil thing that has ever existed in the history of humanity. And somehow we need to come and destroy all of these companies which give us really useful products for free. I'm aware of the fact that we're streaming on YouTube right now, which is something which is an extraordinarily, I think, valuable human invention. And we have to watch terrible ads sometimes, but we have access to it for free. I don't think our starting point should be that Google and how Google operates is necessarily problematic. I think there is something to be said for the idea that this is uncharted territory. The Commission is trying to fix a perceived problem. There's going to be quite a bit of trial and error. I'd be incredibly interested to see what the final DMA looks like compared with the current proposal. And then if it gets enacted, what it looks like in 10 years' time, whether it even exists in 10 years' time. I guess we have to be pragmatic, we have to be brave, but we also probably shouldn't be stupid. And so I think that that's just trying to weed out some of the more ideological. I know I think part of the reason there was so little enforcement in digital markets the last maybe 10, 15 years was ideological, particularly in the American side. But I think that in Europe, there's also something of an ideology of all of this is evil, all of this should be broken up and destroyed and regulated out of existence, which seems like a really dangerous attitude to be holding right now.
Wow, that was a lot more cynical than I am. Don't be stupid seems like a good way to end. I don't think we've actually answered the question whether it's competition law or not. I think my answer would be it's competition law if you look at it from a broad perspective at the national level. If you bring in this idea of economic democracy, protecting small, medium-sized enterprises that you see at a national level, and not quite sure where I stand on that. Some days I love it, some days I hate it. But it exists. Should it be EU antitrust kind of law? I don't think it is. I think your answer is it's not, right?
Yeah, it's not, but that doesn't necessarily mean it's a bad thing. Even I, as a competition lawyer, can accept that in some circumstances there are other socially valuable things other than competition law and policy in this world.
Now, if only people listen to us, Neve. All right, well, I guess that's the end of our presentation bit.
I would say the end of your show, right, was brilliant. Thank you very much. And Vinicius, please.
Thank you very much, Magli and Eve. It was brilliant. It was very nice discussion, very nice debate, and this perspective of the DMA as a regulation and competition law as a regulation where there is a need of a subsidiary regulation is very interesting. One of the things that I miss, like in this, I think it's maybe dangerous, like Niv said, this lack of effects analysis, because maybe we stopped at like evolution of competition law. We're starting to learning how to deal in competition law environment with new concepts like predatory innovation, mavericks, or maybe things like self-favoring. Then you say, no, you don't need that. We're going to use a new shortcut that just say that you are a gatekeeper. And then I can like put a fine on you just because you are a gatekeeper. I don't know, maybe that's not the most complete way of seeing the DMA, but maybe that there is this, I don't know, what do you think about that? Maybe there is this bad side of the DMA, because you can say, no, the competition law is going to continue, and you have just these both ways of achieving things, the 102 and the DMA. But maybe if DMA is easier and I am a commissioner, I would like to use the DMA because I don't need to prove effects. I don't need to do a lot of things. So how do you think about that? Do you think you're gonna have like a switch, not just in the legislation, but in the studies and things like that, to regulation instead of competition on digital markets?
I think the non-effects analysis is exactly why the DMA is adopted, right? So if you look at the justifications, they say it takes too long, the commission has to think about it too much, but also from the company perspective, they don't know in advance, it might take 10 years before they get an outcome. I actually think this is the main justification: make it faster, make it clearer, and increase legal certainty. Do I like it? I don't know, but if it isn't competition law, I guess it's more justifiable. I like the Google shopping decision by Kade, because they talked about this verticalization between the search engine and the comparison shopping product, and talked about the efficiency for consumers, things we hadn't properly seen in the EU. So they're actually thinking about it. But we can't deny that it took 15 years before we actually got to somebody doing that analysis, right? So it was a problem. I like it, but I like it because I'm an academic and I like to study it. I'm intellectually interested in it. Do companies like it? I don't know.
Yeah, I was just that I definitely agree that this is very much deliberate, and it's just intended to kind of get rid of what are perceived to be these problems, that there is this assumption that the current scope and approach of EU competition law is all about hindering these cases. So these are obstacles that need to be surmounted, that need to be, I suppose, pushed away so that we can get on with the business of nailing Google and nailing Microsoft and Amazon and all these evil companies. And there isn't really any discussion of like why it might be hard to apply these rules, which we've spent 50 years honing and developing and making rational, and that are quite sensible rules when you talk about them, why they don't apply so well. And sometimes I think it's sort of an absence of consumer harm. It's harmful for, you know, comparison shopping services that have to compete with Google, and Google isn't very nice to them. But is that actually anybody losing out? And I worry a little bit that this debate is dominated by the loudest voices that are being listened to right now are all very much of one ideological bent. I just actually going to read you a one of the acknowledgements of the Commission issued the EU Digital Markets Act, a report from a panel of economic experts. So they go around Europe and the US and they get economic experts who can talk about this. And the final line of the acknowledgement says, the panel members acknowledge that the lack of diversity in the composition of the panel may have affected the views expressed in this report. So they kind of found all the economists, they're great economists, they're all professors from fancy universities, but they all think the same way, and they all agree, slightly unusually for an economist, that, some vagueness might be a necessary cost to allow the Commission flexibility. So we need these wide, vague rules applying ex ante without any way of taking into account pro-competitive justifications or efficiencies or the case-by-case circumstances. And we have them because we've decided there's a problem and this is the only way we can fix it. And that worries me.
But maybe there isn't any diversity in experts in Europe, Tony. I mean, genuinely, I had the same perspective on this until I started doing this research with OR. And until I started reading what happens in Germany and France, and even in Belgium, my own country. And I was like, actually, I think everybody thinks this way. Everybody thinks we should protect small and medium-sized enterprises as part of competition law, regardless of any effects to consumers. And historically, that's there. So I don't know how I feel about this. There is no diversity, I think. Just it's not there.
I think in the economics profession, there's quite a bit more diversity than this report, which is very much along the kind of Tommaso Valetti, who's one of the authors of the report, his way of thinking, which is just big firms, who cares about procedural safeguards, you know.
Hey, it's about democracy. It's not about economics. Yeah. Anyway, sorry, Vinicius.
No, very nice conversation. Thank you very much.
And I would only add as final remarks on my end, I feel that there's a trend, maybe if this is the right word to say, a trend that you can see in Europe and you can see crossing the Atlantic as well. For example, I've just read and write a paper in Portuguese, but a very short one about that proposition made by the Senator Klobuchar in the US to reform the antitrust law, a very deep reform, and to bringing up lots of vague terms and premises and etc. that if it passes, it will allow the authorities to intervene in a way that we have never seen in the US. I mean, discretionary interventions, right? And thinking that the best to society is to have many enterprises, small to medium enterprises, than huge enterprises like huge firms, right? And nobody knows what will be the outcome. I'm a bit afraid of this, belief. You know, it's pretty much a belief, and I believe this is my personal belief. This is strictly connected to the democracy idea. But is it democracy, or is it like a new political party being launched? Nobody knows.
I agree with the democracy part. I genuinely believe this is a question of economic democracy, and I'm not sure what the right answer is. I've been thinking about this quite a lot lately. I think there is an economic democracy issue, as in big companies with a lot of power distorting economic participation. I think this is a problem. What I'm not sure about is whether it's a competition law problem. And I've had these discussions with competition lawyers who want to take action as part of competition law to solve an economic democracy problem. And I agree that there might be a problem. I don't agree that it should be in competition law, and this is where our roads always diverge. But it's a political belief because I have absolutely no evidence to back it up. I have a family weird Holocaust denial thingy in my head about, you know, big companies, they distort our democracy. Am I right? I have absolutely no clue. I have no evidence for it, but it's a belief. It shouldn't be in competition law.
It depends on which democracy we're talking about, right? If we're talking about a national democracy or a like cross-border democracy where, you know, the big firms, they spread around the world, they are spread around the world, and they are more powerful than the governments itself, themselves actually. So, and it bears a religion, I would say, a religious belief that we should break up the huge and work for smaller and to keep the power fragmented, right? But what power we're talking about? The economic power? Then which power should prevail? The political power, the sovereign power over the economic power? I mean, if we go deep in this discussion, maybe we'll find room to discuss like philosophical problems and so forth and so on. But thank you very much, Professor Neve, Professor Magalhães. Professor Magalhães is a friend, actually. And now I can say, because otherwise, if I said earlier, you would question my my evaluation about what she would speak, right? But she's always brilliant. Thank you very much, Magali, Vinicius, Neve. Thank you all to who is watching us. Thank you very much for your attention. And I hope to see you soon in another event of IBCI or the like. Thank you.
Thank you. Bye.